Welcome, everybody, to the Last Mile Radio with Ryan Leaf. On today's episode, which is one I've been really looking forward to, we welcome Chris Fabricant, who is the Innocence Project's Director of Strategic Litigation and one of the nation's leading experts on forensic sciences in the criminal justice system. His book, Junk Science, I think is a perfect name for it because it's exactly that. Chris, welcome to the show. Thanks for being here.
Thanks for having me, Ryan.
This goes maybe as far back as to the O.J. Simpson trial. They bring in that defense team, and it just becomes all about blood, DNA, all these things like that. And this was from the defense side, right? So the prosecution wasn't really too interested in, or if they were brought down to a different level. Having said all that, watching Dateline, you watch the stories. Most people don't go to trial; they get plead out. But when you have to or are forced to go to trial to save your life, maybe in some instances, it's really about who tells the story better.
Yeah, well, trials are often about storytelling, meaning what jurors are typically looking for is, one, they want to get it right. Jurors are not interested in convicting innocent people, and they're not interested in junk science, they're not interested in liars or perjury. What they want to know is what actually happened, and most of them are looking for an objective piece of evidence. And scientific evidence is really, really persuasive because that's what it's supposed to be. It's supposed to be objective. It's supposed to not have a stake in the outcome of the proceedings. So anytime you have junk science used, it's the ability for it to corrupt the criminal justice process is acute. It's responsible for over half of all known wrongful convictions. Half, right? I mean, of all known DNA exonerations, 52% involved the misuse of forensic sciences. And this is supposed to be the truth-telling serum of the justice system, and it's not.
Science is, and I'm a believer of, science is science, faith is faith, and science is right.
Yeah, absolutely.
A doctor tells me I have an ACL tear. All right, let's go to the expert, fix it, rehab it, and let's go back out. Somebody tells me to get a vaccine. I'm like, okay, yeah. I think I'm probably more trusting. I don't know why. And my wife's completely the different side of it. Like, she's just like, she questions every single thing that exists around wanting to almost self-prove it. The 50% aspect of things, that baffles me because is most of it where they don't maybe use the DNA aspect of it and just talk about other markers or other things like that, and then years later the DNA is what exonerates the suspect?
Well, what's really important to understand is that DNA evidence is available in less than 10% of criminal cases, right? And so this idea that DNA is going to prove innocence or prove guilt in every case is just a fallacy.
Because people don't have the money to do the testing on both sides?
There are lots and lots of reasons. One of the reasons is that DNA isn't available in your typical burglary, your typical robbery, drive-by shooting, and a domestic violence case. All these are very unlikely DNA to be dispositive of the outcome. It's really rapes and murders, and this is why most of our wrongful convictions are these crimes, because these are intimate crimes, and biological evidence is going to be taken, and they're very serious crimes. So it's going to be more available to be tested. What DNA evidence showed, as you think about it, you talked about the O.J. Simpson case, and the reason that Barry Scheck and Peter Neufeld, co-founders of the Innocence Project, were part of that team is because they were two scientifically literate attorneys, which is very unusual, and they understood the power of forensic DNA. And beyond something like for the defense where it was contaminated in O.J.'s case, is that they understood the power to prove innocence. And what was really, really important about when the Innocence Project first opened its doors was the intake criteria. And what I mean by that is that when we were deciding who we were going to represent, we made no subjective judgments about guilt or innocence, right? We didn't care if there were 10 eyewitnesses, the suspect confessed, or there were all kinds of forensics pointing at him. The only criteria was, if we can find biological evidence and test that, will that prove innocence? And that was it. And so we took these cases, and what we learned was shocking. It shook the foundation of the criminal justice system because we learned that eyewitness identification is grossly unreliable. Right. It's the leading cause of wrongful conviction. But what was probably more shocking is that the forensic sciences had played a role in over half of these cases. And these were all accepted by the courts for a century as infallible, objective, scientifically valid evidence. And it had been used repeatedly to convict the innocent. And our work from that point forward was really trying to get better science in criminal courts, because forensic sciences are typically developed by law enforcement for law enforcement purposes. That's not the same as the vaccines you were talking about or these others that are in scientific laboratories and that are subjected to the scientific method. They're not aimed at painting a bullseye around a target, which is a suspect in a criminal case. So that's a really fundamental difference.
That makes a lot of sense, because the individuals that were introducing this science to convict were the ones that were on the law side of things to make it fit whatever their narrative was. Your book, Junk Science, and I want you to speak to this because, it presents an insider's kind of journey through the heart of this broken, and this word here, racist system of justice. And, for someone who's been justice impacted because of my actions, right? It's different talking to a lot of these individuals, because some of them, I was incredibly angry, probably at myself more or less than anything, but I was also incredibly angry, because I was just angry. And you watch these individuals who were wrongfully convicted and have spent so much time away from family and been robbed of all these things to find this peace. And the racist aspect of it, you look around the criminal justice system and they don't look like me. No,
they certainly don't. There's a century of evidence to support this notion that scholars have pointed to for a long time, and that really there's a direct line from slavery to Jim Crow to mass incarceration as an effective tool to control Black and brown people and poor people, right? And those are the people that are subjected to the criminal justice system. And the reason that, I call forensics in my book, or the junk science in my book, poor people science. And the reason that I called it that, this is a pejorative that I, called it this, because that's the type of science that you get in the criminal legal system typically. And contrasting that with the scientific evidence used in civil litigation. So in civil litigation, when we talk about, when Sony sues Microsoft, they're not going to be using junk science to prove those claims, right? And those claims are much better litigated. In the criminal legal system, almost anything goes, and prosecutors can get in essentially anything that they want, and even in techniques that we know have led to wrongful convictions, right? Still today, I talk a fair amount about bite mark evidence in my book. Bite mark evidence is admissible in all 50 states, and we've had almost 40 wrongful convictions and indictments associated with this. I have personally litigated 8 of these cases, right? And walked somebody off death row, a Black man convicted wrongfully of raping and murdering a white woman in Mississippi. And the only thing that they had on him, was junk science, bite marks by the notorious Michael West, right? This is the guy who called me an asswipe during a deposition. So, that it's impacting people of color and poor people more directly and disproportionately should come as no surprise, because that's every aspect of our criminal justice system is that way.
The wrongful convictions and how this affects us in America. How has science and technology evolved? Because you talk about this was built by law enforcement to get to their ultimate goal, but we've seen so much disruption from it, from litigation, from you, the Innocence Project, seeing people who have been wrongly convicted. Why do we continue to kill innocent people and rob others from their family and the time they have?
It's a couple of things you asked that I want to unpack a little. One is, how are we evolving? And the other is, why do we keep using this? And so to answer the second question first, is that anytime you discredit a technique, right? So the FBI and the Department of Justice finally admitted that hair microscopy had been grossly exaggerated for a century in criminal courts in 2012 and went back and audited thousands of cases. That took over 70 wrongful convictions before the DOJ was willing to admit that this was bad evidence. 70 people, right, wrongfully convicted, and those are just the ones that we know about. So the problem with that, though, is that the justice system and the law is fiercely protective of the status quo. And if you go back and you say, okay, yeah, bite marks, we recognize today this is junk science. But what does that mean for everybody? I have 3 clients on death row right now, all put there through bite mark evidence. What does it mean for all those convictions? courts, prosecutors, elected officials don't want to go back and review all those cases, and they don't want to have to overturn convictions based on junk science. So the status quo is really, really strongly entrenched, and it's entrenched in the case law. Once the cases will say that this is good evidence, then it's period, end of story, right? Even though we know science evolves constantly. Science is a process, always moving forward, discarding what we previously believed because we got new evidence, right? The law isn't like that. It's a fundamental tension. So those were, as you say, developed primarily by law enforcement officials for law enforcement purposes. And what we're seeing now, and in the update, in the paperback version of my book, I write about this, is that we are now seeing increasingly technology taking the stand. And this technology is developed by corporate America. And corporate America is in business to make money, right? Not to advance justice, right? That's not their goal. And so there's a lot of incentive to hype the ability of these techniques, facial recognition technology, AI policing, ShotSpotter, license plate reader stuff, fusion centers, all of this technology that's being used instead of boots on the ground type stuff is now increasingly becoming the go-to forensics. And so when those cases come to trial, it's not the Michael Wests of the world that are getting on the witness stand, right? It's a black box that's accusing you of a crime. And the only way that you can challenge the black box is to get inside the technology, to get its source code, to get its algorithms. And that's to vindicate your Sixth Amendment right to confront witnesses against you. And the courts, incredibly, have repeatedly elevated trade secrets and proprietary rights of corporate America above our Sixth Amendment rights to confront witnesses. So this is a pattern we're seeing repeating. Right.
The ability to look in and see what kind of data are influencing the algorithm inside these black boxes, right? Is it more proportionally biased versus this, that, and the other? How do we know that if we can't see what the source code is or what influences that data?
Right. And a lot of it is garbage in, garbage out, right? So they're using, historical data from the criminal justice system to input the new data into these machines, right? So if the data that comes in is biased, the data that comes out is going to be biased.
That makes a lot of sense. The role the Innocence Project then plays in this, and, of course, how I'd love to hear the origin, where Barry came from, how you became involved in it. And I mean, the purposeful nature of what you do, it has to be incredibly difficult to watch it harm so many people. You walk out that building as you leave one of your clients on death row. I mean, I think the audience would love to hear how it affects you, how it pushes you, motivates you, and makes you do something that I walked by on the subway this morning, coming to the thing, the interview today, and there were these two individuals just crumpled over, nodding off on heroin or whatever. Mm-hmm. And I remember there's two women that walked right in front of them, and I walked by too, and I'm like, I wonder if the two women took pause like I did. I was just like go back and grab them and say, I'm here, I want to take you to a... But, I'm in New York. I'm a freaking redneck from Montana, too. And I'm like, I go there, they might think I'm trying to steal their drugs, and they pull a knife on me or something like that. I mean, it's just, I don't know how many people had that conversation in their head, walking 20 feet past a couple heroin addicts, in the subway system, bent over. But I think there's an empathy that has come that I didn't ever have before. And you have to sit in that world so much.
Yeah, well...
Sorry, that was a lot, so you can start from the Innocence Project, where you got there, and everything.
No, I understand. I mean, system impact people like yourself, you have a whole new perspective on the system, I imagine, and it's been true with everybody that I know that have been impacted. My father was a public defender. It's actually how he and my mother met. My mom got busted, and my dad represented her. And which is an unethical relationship that you shouldn't have been in. That's probably why the marriage lasted about 10 minutes. But you came from it, though. I came from it, right? Go. Another defense attorney. Yeah. So I always knew that I was going to be a defense attorney, and I've never done anything other than criminal defense. When I was talking to my team just the other day, about, a lot of people feel very vulnerable right now and with the state of our world and the state of our country. And what I always talk about, is I feel really, really lucky to go to work every day and pursue justice. And we're not making widgets, and what we do matters, And I don't know if I could do anything that I felt like was just to make money. And I've been one of these lawyers that's been really, really lucky, and I've spent my whole career in public interest, And the work that I did as a public defender in the Bronx, at the Bronx Defenders, and when I was an appellate lawyer at Appellate Advocates here, it was just as fulfilling as working at the Innocence Project. I mean, I have the greatest job in the criminal justice system. I love it. And I'll talk a little bit about how I got into it. But being a public defender is, if Jesus had been a lawyer, he would have been a public defender, right? I mean, without question, right? Because he was with those that are despised. And you just described the people despised on the street, right? Jesus sit down there with them, right? Massage their feet. And so there is no more righteous calling in my mind than being a public defender. It was just too insane of a job when I started having babies. It was like, it was too much. So I had been doing that work. And then anybody that is, that has stood in arraignments next to clients and seen the same type of garbage coming in, and I don't mean our clients, I mean the charges against our clients, day after day after day, is going to start to think about zooming out and wanting to work on larger issues, right? Because the system is so fundamentally broken. And, when the Innocence Project had learned lessons for the 20 years that the doors have been open, we talked a little bit about how we discovered all these leading contributing factors to wrongful convictions. And so what Barry and Peter wanted to do was start a strategic litigation department. And that department, my department, is focused on eliminating or mitigating these leading contributing factors to wrongful conviction. So, there's one attorney in my department does only eyewitness identification work. There's another that only does false confession work. There's another that only does forensics with me. And there's one lawyer that's only working on digital forensics, right? And our goal really ultimately at the Innocence Project is to go out of business. And, unfortunately, it's not happening.
The separate kind of sections in which they branch off to, if I'm hearing you correctly too, it's not just about a client in those fields, right? They're in sections of this Innocence Project to dispute this junk science, to try to get it ultimately thrown out of what could be used to convict people in the future.
Yeah, it's our role, sometimes we'll involve ourselves in hearings, pretrial hearings, to prevent the use of junk science being used in a trial, right? And our role that we view in that type of a case is to prevent a potential wrongful conviction. If you're going to use, people go to trial, people get convicted, and that's our system, and, we've got nothing to say about, the guilt or innocence of somebody that hasn't been tried yet. But we know that the search for the truth is not advanced through the use of junk science, and so we want to try hard to get better science used in court, because there's no organization that relies more on valid and reliable scientific evidence than the Innocence Project. Our whole foundation is based on that. And I don't advance any arguments that are contrary to the scientific consensus. We rely on the scientists to tell us.
Yeah, you want the truth.
We want the truth.
You want the truth because the truth is the only thing that there's no bias to that. You're not, of course, your bias lends itself to the freedom of these individuals, not because it's a monetary gain or it's a stat or anything like that, but the truth is just simply the thing that I'm sorry to be cliche, sets people free.
Right. And we should talk about bias, because bias is a really important aspect of junk science.
Okay.
and the role that it plays. And
bias and stigma, right? Kind of go hand in hand.
Yeah. Well, this is another type of bias, cognitive bias.
Okay.
And what I mean by this is that, I want your listeners to understand what I mean when I call something junk science. And what junk science is something that sounds like science, walks like science, but it doesn't talk like, it talks like science, but it's not science, right? Because it hasn't been subjected to the scientific method. There's no measurements taken. It's somebody's judgment that's being used. And with that type of evidence, you have subjectivity. And with subjectivity, you have bias, right? So one of the really famous misidentifications by a fingerprint expert, Brandon Mayfield, for bombing a commuter train in Madrid, Spain, right, in 2004. This is mild-mannered lawyer in Portland, Oregon, who had never left the country. And his prints were alleged to have been found on the blast caps in the rubble of this train. The FBI matched him to these blast caps, and then they looked at his background, and he had recently converted to Islam. He had married an Egyptian national. He had once represented a man that was convicted of providing material aid to a terrorist organization. So all those facts are much more significant than the actual fingerprint, right? And the FBI, he was arrested, he was held incommunicado, charged with these crimes. The court, because he was so insistent that that was not my fingerprint, the court hired an independent expert and to reevaluate the fingerprints. That expert came back, said it was Brandon Mayfield's print. Brandon Mayfield's defense team hired their own expert to do an independent evaluation. His own expert came back and it was his print, right? It wasn't until the Spanish authorities identified an alternative suspect who was a better match that the FBI finally admitted they were wrong and he was released. So this is a shockwave across the forensic world, right? Because bite marks, are one thing. Fingerprints, though, are the top of the heap, right? As far as trace evidence goes. And so bias had not been spoken about in forensic literature almost at all in the 100 years that it had been in use until this case. And Dr. E.T.L. Dror did a study right after this to kind of test the influence of totally irrelevant facts. And we know the irrelevant facts that these experts are getting. They're prosecution theories, right? It's not the defense theories that they're exposed to.
So simply just those things you talked about, written down, this is just married an Egyptian national, all of those things that you discussed.
Right.
They read that through that thing and then go to study the fingerprint.
Exactly.
Okay.
So that's biasing information they get. So
that can lead to them looking at a fingerprint differently.
And so the test that was done to demonstrate the power of this was done by Dr. Dror in the aftermath of this case. And what he did is he took a group of latent fingerprint experts, all highly qualified, board certified, very experienced, and he gave them casework and asked them to do evaluations. But what was clever is that it was their own prior casework. They had already come to conclusions on these.
But they were so old, they don't remember.
You're not going to recognize a fingerprint, you know what I mean? And so the only thing they changed was the totally irrelevant information in the case file, right? Things like the suspect confessed or there's an eyewitness or something like that would point in one way or the other, right? 3/5 of these experts changed their original conclusions from identification to an exclusion based on nothing but totally irrelevant information. So all forensics have bias, subjectivity, and some much more than others. And so we show the power of totally irrelevant facts to influence so-called scientific evidence. And still today, outside of the FBI latent fingerprint lab, is that overwhelmingly, experts make no efforts to shield themselves from totally irrelevant information. That's junk science.
How does when that study is released and it's unbelievable information to individuals like yourself or other people, defense attorneys, public defenders who are just overworked, may never ever have a chance to fully understand that, maybe even in their own sense. Is that just then tossed away as in their own eyes, as prosecutors, as judges, as the criminal justice system, as their own version of junk science in their mind?
You could get a prosecutor on your show tomorrow and probably disagree with everything that I've said.
Yeah.
And these are all facts. You can look them up. I wrote about them. I'm available. For the debate. But it's a highly politicized area of science. It's like climate change. Is that there are really, really strong investments in the status quo, and they just won't buy it.
That status quo you talked about earlier, just talked about now. This even happens after, deputy prosecutors are voted out, and there's their predecessor or two predecessors before them have the conviction on their record, and they're unwilling to even relent because of that status quo.
Yeah, I devote a chapter in my book called that's related to the principle of finality and why it's so hard to overturn a wrongful conviction. And one of the aspects of this that is often overlooked is that whenever we are going back into court and we say we have new evidence, we have new DNA evidence, we have a new witness, we have something that shows our client is innocent, that case is filed in front of the same judge who presided over the trial, and it's defended by the same prosecutor who tried the case. So you can imagine the type of bias that's going into that nobody wants to believe that they convicted an innocent person. And beyond that, the political pressure, the civil liability aspects of it, there's all of these, plus the law is totally stacked against us in 10,000 different ways. So it makes it incredibly difficult. Just 2 weeks ago in Monroe, Louisiana, we did a week-long evidentiary hearing in the Jimmy Duncan case. And Mr. Duncan was wrongfully convicted based on bogus forensic pathology testimony by the notorious Dr. Stephen Hain and bite mark evidence that was developed by Dr. Michael West and then also testified to by a different dentist at trial. And this conviction in my mind is plainly a wrongful conviction. Our client has been on death row for 30 years there. And the original trial prosecutor had been retired for years, came out of retirement to defend this conviction. So you are not getting, a new objective view of the facts, right? We're getting people that are dug into these facts and don't want to believe that it's possible they could have made an error like this. And I'm not saying that anybody did this deliberately, but you don't want to believe that you prosecuted and put an innocent man on death row. You just don't.
Or killed them.
Or ultimately. Killed them, right?
I wanted to ask you this. We're talking about, cases that go to trial. I would suspect that a lot of this junk science is so forceful that it may send a ton of people who are just simply charged into wrongful type of plea deals.
Absolutely.
Because of the time or the possibility of a death penalty or things like that before you even get a chance to go to trial. When that happens, when a plea deal is done, that eliminates any type of process from you guys, I would suspect, because
No. I think it's more than 15% of our cases, our clients pled guilty to crimes that they did not commit, including capital crimes. And this is often because they're threatened with the death penalty, often because there's the threat of junk science. I worked on a comparative bullet lead analysis case in Arizona that was similar to that, in that clients who were pleading guilty, because it's impossible to, if you want to try to cross-examine your way out of a junk science conviction, you're lost. Maybe you get, Johnny Cochran and Barry Scheck come in and maybe, you'll have some outside chance of creating reasonable doubt. But overwhelmingly, scientific illiteracy is a huge problem with the defense bar. It's a huge problem with prosecutors and judges too, and with jurors, right? And so you have this evidence that courts have accepted. They're going to come and bring it in your trial and say that this proves your guilt. It's, the irony is impossible to miss, but it's a rational decision for an innocent person to plead guilty and not expose himself to the death penalty or an insane amount of time. And we see it all the time. And you want to talk about, lower level stuff. We talk about drug cases, right? These presumptive drug tests that are total garbage, but people get arrested on them and then they have to plead guilty at arraignments. Maybe they didn't have drugs, and that has happened a lot. People had aspirin and all kinds of other things but then they have a record, and they're not going to get bail and they're going to have to plead guilty.
You talk about the bias of, there's so many identifiers that a person walks into a room with, right? Especially one that, in my case, I walk into a room and I'm a 7-time convicted felon. I'm a drug addict. Those things carry with me, and I don't care about it anymore. But that's a personal journey on my part. It doesn't affect the other people in the room, right? Right. The individuals that see it, jurors, right? What's jury selection called again?
Voir
dire, yeah. That process, the importance of it, the idea of let's say a chairman on the jury, you know, is a smart individual who understands some of the forensic science that comes along, where the other 11 are more a jury of our peers, you know, where they're just confused with what's going on and how they can be swayed in a direction that way too, of the bias. And it's just it's the justice system, and it's the only one we've got. And it's so we look at it this, that, and the other. The idea of your status quo portion of it, I knew that people were unwilling to compromise because A, they don't want to be held responsible. They don't want to have maybe the guilt of what comes with that. Also, it's just what's been done, right? And what's been done, I fear the unknown. And let's just wear the blinders to it. So when you talk about the status quo and the people that are unflinching, unwilling to change, that may be the most disappointing part of this whole process you're talking about.
Yeah, you know, I mean, we had a client that, you know, was executed about a month ago, Mr. Williams in Missouri. And the DA in that case was opposed to his execution, and the Attorney General of Missouri went ahead with it anyway. And for a district attorney to come out and oppose, this is true with Richard Glossop's case too in Oklahoma, you know, I mean, who is currently on death row, and several other cases around the country, where to get the original trial prosecutor to come forward and admit that there are problems with the conviction or that our clients are innocent, and then have that opinion rejected is
what was the answer in both those instances?
The AG didn't believe it, said he's guilty, right? We're going to go forward with the execution. You know what I mean? And these are very politicized decisions, right? These are elected officials, right?
Could victims' families be...
Oh, yeah. You know what I mean? And victim families tend to, as we would anticipate, believe in the conviction. Nobody wants to believe that, you know, justice wasn't served.
Right. Because if it wasn't, the person that did this to my family was never caught, out there, and has gotten away with it. And I'm less willing to think that or accept that than to know what my fear and what my, you know, nightmare is.
Yeah, you know, I remember really well Alfred Swinton's case in Connecticut. It was a client of mine, and the day that he was exonerated, he was thought to have been a serial killer, and there's at least one, maybe more than one serial killer working in Connecticut, and was killing sex workers for a long time in the 90s. And my client Alfred Swinton was convicted of killing one sex worker, but was believed to have committed, you know, many other murders. But the only thing they had was this so-called bite mark evidence on this one, and he'd been seen once in the vicinity of this person. And DNA proved his innocence ultimately, amongst other things. And the district attorney was not persuaded by, it was a new district attorney, was not persuaded by the bite mark evidence, was willing to re-examine the case. And, you know, what we at the Innocence Project are very sensitive to victims and victims' rights and the impact that an exoneration can have on a victim's family, right? Because we're all trying to, you know, pursue justice and pursue the truth here. And it's very, very emotional, of course, for everybody, right? And I remember when the judge was going to dismiss the indictment, and you could feel the energy in the courtroom. And I remember telling the court officers, I was like, you got to keep the victim's family separate from us. You know, there's going to be a scene. And the case gets called. He's exonerated, and then we're just walking out into the hallway, and I could see them making a beeline for us. Right? They totally ignore me, and they spat on us. And, you know, my client had just been exonerated. He'd just spent 16 years in prison for a crime he didn't commit. He's an old man, you know what I mean? And it was so astonishing, but not surprising. And I felt so, you know, I was disgusted, of course, but it was also so badly for them because, you know, these are very poor people who suddenly, you know, their sister, their mother didn't get any justice, didn't feel like this person should have been let free. And it was really just nobody wins in a wrongful conviction. And this is a really good example of it.
Did they end up finding out
who did it? No.
Yeah, that's the... So let's just go to the like the changing climate around politics and everything like that has just taken place here in our country. And again, it seems like my day was just full of it, right? So I'm waiting by the elevator to go go down the elevator on the subway, and there was, four or five uniformed police, NYPD there in there, and I just, I don't, just policing, I assume, but we're all standing there, everybody's standing there, but just as the elevator goes, I watched these two officers come towards me, but they weren't walking towards me, they were walking towards the person behind me, and it was just this young kid in a red hoodie, listening to music, and they stop him and ask him for ID. And I just, again, I was like in this moment, I'm like, why do you need to see his ID? I said it, and then I just was like, shut up, and I just kept walking. But I didn't maintain it. Like, why do they need his ID? I mean, why didn't they ask me for my ID?
Right. When I was...
And he's black, by the way, so...
and probably all your listeners were already assuming that,
yeah.
Right? When I worked at the Bronx Defenders and when I was a clinical law professor at Pace Law School for a few years as well, and worked on these issues related to stop and frisk, and, what we saw and what we knew in New York was that it was something like 98%, 97% of the people that were stopped and frisked were people of color. And that overwhelmingly, close to like 95% had done nothing wrong at all, right? And that they were just getting harassed by police constantly, and I had clients that would be stopped several times a day, routinely, right? And we could see that this was obviously being racially profiled, right? And the law allows for it essentially, unless it's systemic the way that it was with the NYPD. And we saw, that even after we had won lawsuits against this with the Center for Constitutional Rights and NYCLU and other organizations, and then we saw Bloomberg start to double back and double down on it, right? And Mayor Adams and the same thing, right? This constant need to harass black and brown people. It's been this way for 100 years. This is the role that the criminal legal system often plays in our culture. And what we see now when you talk about the advent of technology is the digital stop and frisk, right? Is that entire neighborhoods are under perpetual lineups, perpetual surveillance. Their biological data, biometrical data is constantly stored in police databases. And that's the kind of data that is used from these, emerging technologies. So the issue is not going away. It's not going away.
I've always been of like, the horrific things that happen on the side of the road when traffic stops are made. Like, I've gotten most of my tickets in my life now here in the last 10 years with technology saying I was speeding, through pictures or went through a red light with a picture. And I'm like, those are things that can be taken care of that removes all that type of possibility of further things that escalate or happen. The technology aspect of things, and I may be the completely different person in all this. Like, I've been as transparent and accountable with everything that I don't care what anybody has. Like, so, I'm like, you want to see my search history? I don't care. You want to know where I'm at all times? My wife has my Find a phone on my phone. She knows where I'm at all times. Like, if I'm in the wrong place, then I should be called out on being in the wrong place. Sometimes that's so I don't care about all that stuff.
Right.
People who care about their personal privacy and things like privacy, that's just I think it's something that may be taught or just something that, like, I don't care about that. So the biometric stuff you just talked about that's used in neighborhoods and everything like that, where does that bias come into play then with what the prosecution then ultimately uses if a facial recognition of someone in that neighborhood they've been under surveillance for, years on?
Fundamentally, the bias comes in who we choose to surveil, right? Is that we know...
Right, is it in the suburbs in Connecticut looking at my family and everything?
Of course not,
no.
Right? And we know that black people and white people, rich people and poor people all use drugs at about the same levels, right? And so there's no particular need for it, in one particular area. Now, what the argument will be is that these are where the crimes are committed. So this is where they made the same argument in stop and frisk, right? So there is some reality to that, but there's also needs to be transparency, right? And so most folks and we're learning this through our own work at the Innocence Project and elsewhere, aren't even aware of the technology that's being used, aren't aware of their biometrical data that's being used, and they are aware that they're being policed a lot differently than they are in Connecticut, right? And so you can't just not grant entire communities the presumption of innocence, right? You don't become suspicious or a potential criminal or a suspect simply because you live in a marginalized community, right? That is illegal. That's unconstitutional. And to be surveilled like this, to be this digital stop and frisk just because you live in a particular area, in my view, you have to have particularized suspicion. You have to have a reason beyond being black and brown and living in a particular community.
I don't know why it just, like those two images today, I wanted to say something, and there's just I don't know what it is. It's just, what am I going to do?
New Yorkers don't want to get involved, right? You know what I mean? Is that
I want to do the right thing.
Right, right. What does that mean?
What would I do there? Would I make it worse?
I don't have the answer for that. Right.
All right. So, can you speak to maybe some of the current cases that you're currently on, and how maybe the listeners can help?
Yeah. I mentioned the Jimmy Chris Duncan case in Louisiana. He's the last known victim of Dr. Michael West and Stephen Hayne on death row. We're waiting for a decision in that case. That's going to be a very important case. We have a client named Charles McCrory in Alabama that Sonia Sotomayor issued a concurring opinion in Supreme Court when his case went to the Supreme Court and they denied it. But what was really incredible about Sotomayor's opinion in that case is that she acknowledged that 1 in 4 people, and this is all wrongful convictions, so I talked about the 52% number, that's from DNA exonerations, but the National Registry of Exonerations has thousands of them, and 1 in 4 on that registry were convicted by junk science. Also talked about essentially what we know is that 2.3 million people are in some form of incarceration in this country right now, and by far the highest rate in the world. You think maybe 1% of them have been wrongfully convicted, which I think is a very conservative number. You're talking about tens of thousands of innocent people in prison. And what she pointed to was that, this due process right to be convicted on unreliable evidence hasn't really percolated through federal courts, sufficiently. So we're not going to take this case. We don't really have, the law to overturn an obviously innocent person. Because Mr. McCrory, he, on the eve of his evidentiary hearing, with my co-counsel from the Southern Center for Human Rights, Mark Loudon Brown, we got a phone call from the DA right on the eve because he'd been in prison for 37 years. He'd been convicted of murdering his wife, and while his 2-year-old son slept in the room next door. There was no evidence against him, no eyewitnesses, no confession, no forensic evidence, nothing. What they had is that when they searched his house, they found homemade pornography that depicted bondage scenes. And this is in Andalusia, Alabama in the 80s. And that he became a suspect as a result. And they argued in court that this was motive, right? That it would escalate necessarily to murder. But they didn't have any evidence. And so what they did is they got a very famous forensic dentist named Dick Souveron, who had testified in the Ted Bundy case, to re-examine this evidence. And he decided that one of her injuries looked like a bite mark. And he testified at trial that that was a bite mark and that only Mr. McCrory could have made that injury to the exclusion of everybody else, right? And what they didn't examine was that there was an open window in the back of the house. There was a fresh boot print below that window. There was no fingerprints taken on the windowsill. There was a red bandana found next to the body. Fast forward 30 years, when we took up the case, we discovered that hairs in her hand, the victim's hand, didn't come from Mr. McCrory, didn't come from her, the likely perpetrator. The red bandana, there was a guy, a construction worker next door to his house named Ainsworth, who 3 weeks after this murder committed a home invasion rape and did 20 years for that. He was known to wear a red bandana and boots, right?
So he's already out.
He's already out. So then, to his credit, Dick Souveron recanted his testimony, admitted, I can't even say this is a bite mark, right? Let alone that I can associate it with Charles McCrory. So we're going to the courthouse. We get a call. The DA offers us time served. 37 years he's been in prison. 37 years. He walks out that morning free, home to his now 39-year-old son who's always believed in his innocence. He turns it down flat. No chance will he plead guilty to a crime he didn't commit, to the murder of the mother of his son. And he wouldn't even talk about it. He was just like, no way, no way. And, if it's me, I'm going home, right? That's enough time.
How do you not counsel him to?
It's his life.
I know.
You know what I mean? No, I
Did
was
you
just
try?
like,
Did you try?
Yeah. You know what I mean? It was just like, we don't know what's going to happen in an evidentiary hearing. Anything could happen. And the worst happened, so he turned it down and we lost. And we lost in appellate courts. And then the Supreme Court didn't take up the case. And now it's back in federal district court where, the state is still defending it and still defending the bite mark evidence in it. So, this case, Charles McCrory, our case, Jimmy Chris Duncan, most people are aware of the Roberson case in Texas, who was narrowly avoided execution a few weeks ago. There are, all of our cases are critical, and so, one thing, if you ask like what your listeners can do is they can serve on juries. They can be skeptical of prosecution evidence. They need to also be aware. And what that mean by that is that there are efforts around the country to change laws that acknowledge the progress of science and give prisoners an opportunity to go back to court to prove that the evidence that was used against them, the so-called scientific evidence, has been discredited. So there's a handful of states have these laws. And the Innocence Project is making efforts to pass more of them in other states. And what that means fundamentally is that where courts need to acknowledge that, if we're going to use scientific evidence, we have to be comfortable with uncertainty because there's nothing certain in science, nothing. No, there's that's not what science is about. And we have to acknowledge that this may change. And as a result of that, we can never have a death penalty either, right? Because nothing is that certain.
As certain as death.
Nothing is as certain as death. It's certainly not science.
No, the idea of finding a new technology years later that would have exonerated or put somebody in that position. Yeah, I was being incarcerated. You do find this, and I will say I was probably in, the most reasonable adult daycare you could have in Montana. Though, I mean, there were men in there that, I think one of my first roommates had murdered his entire family. So it wasn't like lower security or anything like that, but it wasn't rampant with gangs so I didn't fear for my life or anything like that.
Yeah, you're an ex-NFL player too, right?
I was about 325 pounds at the time too, so for people to move me off my spot, it would have taken quite a bit of work. But still, when I walked out of that place, I almost had a differing opinion because I saw that it wasn't necessarily a real deterrent. Mm-hmm. That I was like, if people took another person's life or did some of these things that were absolutely abhorrent, I could understand where the death penalty was. Working in criminal justice reform and then hearing the stories around the things that, how would I know that was truly the case when they're in their case? Mm-hmm. I don't know. The ever evolving of science and those things that depict that make sense of it, even if I felt for a time that, I don't want to go back. I like my life now, but I also know I lived through it and it wasn't the end of the world. But maybe that's just a perspective I've developed. I can't imagine being there for not doing the thing that I was convicted of for that amount of time. This has been, I tell you what, I've worked in the broadcasting world now for 10 years, and the sports broadcasting side of it. Recently worked with a couple different groups here with the Last Mile and with the Menninger Clinic down in Houston, and the purposefulness of it that you spoke of. It's incredibly meaningful. What happens when a client that you feel you've failed, which you've never done, but is then in a situation where on death row is executed, or how do you confront that, take that on, have to discard it and go to another?
My sense of outrage is what gets me out of bed and to work every day. And that's, I channel all of that energy into that work. I don't get overly emotional about my cases, and I've been doing it for 25 years, I mean? It's, of course there are many clients who kind of get to me, I mean? But if they all did, I mean, I would never get out of bed at all, right? I mean? And there's, the criminal justice system brings nothing but pain and suffering. That's what it's designed to do, right? That's its purpose, is pain and suffering. So if you're not prepared to deal with that, you shouldn't be in the business. You know what I mean? That's the bottom line. And, at the Innocence Project, unlike, other places that I've worked, the tragedies are exacerbated by innocence. Right. What I mean is that, so many of the lawyers at the Innocence Project have clients that they know are innocent, but they can't prove it, or that the DNA evidence got destroyed. In Charles McCrory's case, the evidence is totally destroyed in his case, so we can't test the DNA, right?
Can't taste the hair that was in her hand.
Nothing, no. So the only thing that we can do is show that he was innocent, right? He would have taken that plea. I mean, he wouldn't have rejected that plea, right? Sotomayor wrote about that, said, geez, I mean, wouldn't, that seemed to me really strong evidence.
Why would somebody do that, right? You could walk free and clear.
Right now, right? Because none of us have been in the position, of like saying, I'm guilty of something I didn't do.
This has been great. Chris Fabricant from the Innocence Project. He's the Director of Strategic Litigation and one of the nation's leading experts on forensic sciences and the criminal justice. Get his book, Junk Science. It presents an insider's journey into the heart of a broken racist system of justice and the role junk science plays in maintaining the status quo. I haven't heard the status quo part of it. It makes a lot of sense. It's very enlightening. Chris, thanks for taking the time to be with me today. That was if anything I can do.
You're helping spread the word.
If there's anything where you go somewhere where, you need to give someone a little bit of hope or something like that, I don't know. I'd be more than willing to just jump on a flight, go with you and just put myself in their shoes and maybe take a weight off them for a little bit. I don't know.
Well, thanks. We'll be in touch.
All right.
Thanks for having me on.
There you have it, everybody. Chris Fabricant from the Innocence Project joining us today here on the Last Mile Radio. As I sign off here, it's just important for everybody out there who listens and knows that I'm really one of the most grateful and lucky men there are out there. You will not believe the opportunities that I've been presented just here in the last 10 days because of people who believed in me, who gave me a second chance, and what I get to do. And so I just want you to know when you're listening to this that none of this is taken for granted. You're going to get the best from me when I want to interview these individuals, whether that's someone who is fiercely for criminal justice reform or fiercely for prosecuting it. So stay with us. Stay with The Last Mile Radio with Ryan Leaf. We'll see you next time.